almost lost their life because of the reason that that building that was there, that the building that they were in was unusually old. It was like very, very old. And something happened because of which the building simply fell. Okay, it simply fell, and this guy was left hanging from a floor. Okay, with his two hands there, he was left hanging from a floor. So this kind of situations really call for instances where you have to be very careful. Societies, standalone building, societies or people who are managing these kinds of properties need to be very careful, particularly residential commercial properties need to be very careful about the fact that there can be structural changes, there can be redevelopments that are needed. Sometimes the whole thing needs to be kind of redeveloped in as required if it's too old. Okay, and this is particularly relevant for properties in Mumbai. So to deal with this aspect, but there can be like typical issues that arise or roadblocks that come into place when someone is actually looking to have the properties redeveloped. And uh, because of that, even the necessary redevelopments that need to be carried forward cannot be put into effect immediately or as desired. So therefore, to deal with such issues, we have with us Mr. Jayom Shah. He is a counsel at Bombay High Court. We had him in place for just in earlier in the week for a session on writ petition, which was very well appreciated by everyone. And he has got an incredible degree of experience in real estate litigation. So today he's just going to give us kind of an overview of what redevelopment looks like in the real estate scenario, and what kind of problems people can actually face. Okay, and this is we'll deal a lot with Mumbai because it's kind of big in Mumbai. So welcome, Mr. Jayam Shah.
Uh, Thank you, Komal, for this introduction and, of course, setting a prelude to this particular discussion on a webinar right now. I welcome all of you all over here, all the participants who have come over here. And I can see, a lot of them are also advocates, apart from law students. Some of them I probably know also. Before we start, let us set the expectations clear on this. Redevelopment, what is it? That we will first talk about, and later on, you see, the laws are there. There are a plethora of laws. There are a varied, there's basically a basket of laws which deal with redevelopment issues and everything. But if you really want to understand the law properly, why it has been enacted, you have to go what problem is it trying to address? What is it trying to cure? That is a reason for enactment of any law. So for that, many people go into the statement of objects and reasons. They would also go into the law commission reports. Law commission reports are made by the government, of course. However, that is the perspective of the government, what experiences they have had, and that is what is included. Of course, it is based on facts, it is based on law. But many a time the realities are even much more than what is even stated in the law commission report. Having said that, the reason of conducting this is to actually tell all the audience over here the historical background why this redevelopment concept has come into Mumbai. If you really see, apart from Mumbai and the regions around, this concept of redevelopment is not so very popular everywhere else. Even if you go in Delhi, do a Google search in Delhi, it will only talk about redevelopment of the Central Vista, which is the Parliament building, and Rashtrapati Bhavan. In Gujarat also, it was been only about posts, but there is no particular, a general policy about redevelopment as such. But only it is in Bombay. Now, why is it so? Is there because there is a historical perspective. So today, while I am giving you an overview of this redevelopment, I'm basically trying to go back into history. It is once you understand the history, why this thing has come, would you be able to appreciate the law properly and the practical problems that are arising out of it. So let us start with this. What is redevelopment? It is basically the action or process of developing something again or differently. From a real estate perspective, it is construction of new buildings in an urban area, typically after demolishing the existing buildings. Now, world over, buildings can be demolished, they do come again, but in Mumbai, it has a particular purpose to be served. Now, for that, there are three basic fundamental reasons why this becomes very peculiar over here. The first is that Mumbai is an island city. It can only grow northwards, unlike other cities. Now, if you see Calcutta, it is, like around 300 years old. It is much older than Mumbai, but it has areas to expand. So is the case with Delhi. So is the case with Ahmedabad, and of course, many other cities. This is just an example. The second reason is that the kind of chawls that we have in Mumbai are again very peculiar to this city, unlike other cities. Slums, of course, there are there in various cities, but the quantum, the magnitude, the expanse of the areas in which slums have come up is exponential. It is of a very great magnitude in Mumbai. Again, we have a problem of constant influx of migrant labor, Mumbai being the financial capital and being the city of dreams. Now, what is the genesis of this? I have already spoken to you that we are going to talk about the genesis. So let us quickly go through the history of Mumbai. Mumbai, as you know, that it had been a 7-island collection with a good bay and a good port. So right from the sultans and the Indian rulers, it had changed hands from the Portuguese, then finally to the British. There was a fort in the fort area, which we popularly know as fort. Then there was an island city over which the Mumbai Municipal Corporation was giving the municipal services. It was established under the 1888 Act. Beyond that, until places like Matunga, both the central and the eastern part of it, we had the Bombay Improvement Trust Board. Many of the popular suburbs that we know as Bandra or Ghatkopar or Andheri, these were all talukas at those particular times. They had their own municipal, they're not corporations, of course, but municipal councils were there. Slowly, the BMC's jurisdiction gradually extended, and today the current territorial limits everybody knows. While it was expanding, many of these lands were actually collector lands and the municipal corporation's lands. Of course, we have a freehold land system also. And then there were various other kind of tenure of lands that were there. There was a abolition act also of that. So many of these lands had become a private ownership. In those days, between 1988 to 1920, when the influx of population was high, there was an excessive need for housing stock. They came up in the nature of chawls, which were typically between 150 square feet to 225 square feet. And today our government talks about affordable housing, mass housing, rental housing. In those days, there were no such concepts. And the people who actually provided these kind of housing were actually private entrepreneurs. There were this class of landowners who, out of their own money, they constructed these buildings. They gave it to these workers and migrant population. In those days, there was something popularly known as toblet, and people used to wonder, what is this toblet? It was not toblet, it was to be let. So landlords were more than eager to have tenants in their building. They were more than welcoming at that particular time. Even if you wanted to exchange a tenement, they will do it so very easily. There was no system of pagdi. Pagdi is the premium system that we pay today. It was not in those days. No premium had to be paid. And the government's contribution to the housing stock was minimal. I mean, it was really very, very negligible. So the role of the private sector was very high. The rental economy was good. The availability of tenements was very good. In fact, the supply exceeded the demand that time. There was a free market economy. Now, what really struck, it was something out of the blue when we faced World War II. There were some problems in Bombay also, which is in Gujarati, we know it as Godika, Dhadaka. Many people started leaving Bombay. Now, because of the World War II, we being a British colony, we were also experiencing inflation, economic problems, financial problems, rents were rising, prices of commodities were rising. So at that time, the government said, there needs to be a freezing of rent. There was some orders that were passed, which later on got converted into the Bombay Rent Act, the full form being the Bombay Rents, Hotel and Lodging Housing Rate Control Act 1947. Now, this was supposed to be a temporary measure. There was freezing of rents, of course. There were protection being given to the tenants from eviction. However, this thing should have been there for 5 years. It stayed up till 10 years. But after that, it should not have been continued. But unfortunately, due to political compulsions, and I quite aptly put it as rather vote bank politics of appeasement, that this rent control, i.e. the freezing of rents, it actually continued. The tenants class was given to understand that, this is good for you, this is necessary for you. The fact of the matter is that the tenants actually never asked for it, the larger part of it. And later on, it got into their brain. It was in fact rather ingrained into their brain that the rent should not increase. The prices of all commodities increased, except the rents. Now, of course, there was a political mileage that people would have got out of it. But what happened is that slowly and steadily, the taxes increased, so much so that the taxes, the municipal taxes even exceeded the basic rents. The expenses increased. The cost of maintenance and repair of the buildings increased. Initially, the landlords gave in, they used to do it. They used to do it out of their own pockets. But later on, it became uneconomical. It became unviable. Resultantly,
so this is with reference to, let's say, rented properties, and why this kind of became typical for redevelopment is that you are trying what you are trying to address.
Yes. See, why I know we'll all come for redevelopment laws and all, but as I told you, of course, I'll take you through the redevelopment laws also, what is applicable, how it has come. But why am I giving this historical background is you need to understand that, because not many people know the truth behind this. Fortunately, I've dealt with certain litigation, so I know about the real reasons behind that. So I can go with it a little quicker if you want. Tell me, Komal.
Yeah. So, like, they would want to know how they want to hit on why or how the historical background is directly connected to redevelopment. That's where.
Yes. So this is what I'm coming to. So what eventually happened is that the landlords started not giving the housing stock on rent anymore. Later on in the 1960s, there was more thrust on the ownership of buildings. So you see the Maharashtra, the Maharashtra Regional and Town Planning Act, of course, came in 1966. The Maharashtra Cooperative Societies Act came in 1960. The Maharashtra Ownership Flats Act came in 1963, followed by Maharashtra Apartment Ownership Act 1970. As we see at all these acts, why am I giving the reference to this is that the thrust was on ownership housing. Resultantly, what happened that the rental housing segment was being neglected. there was an artificial shortage that was being created. Now, due to this, what happened that people started only giving flats on leave and license basis. That too, with a lot of fear in their mind. Now, these leave license basis flats that were available, that were very high. So the lower economic segment, the middle economic segment, many a times, they could not afford these leave license flats. They also could not go to the formal rental housing because landlords were not giving. Resultantly, what happened is they started going to the slums. The slumlords were charging more money than the landlords of old buildings. But of course, they were lesser than the leave and license flats in the formal housing sector.
Yeah.
And that is how the slums started mushrooming in the city. Now you see how everything is interconnected. I'll just pause here for a moment. Why am I talking about landlords? Why am I talking about leave license flats? Why am I talking about slums? Because this has become a very, very big problem. Because these things are there, is that we are talking about redevelopment.
All three things are majorly prevalent in Mumbai. Like leave and license agreements are also majorly carried out in Mumbai. Slums also, existence of slums, like the biggest slum of Dharavi. These are all typical, existence to Mumbai.
Absolutely. Now, you will be astonished. There was a government constituted committee, which was popularly known as the Suthankar committee, which had submitted its report also. And very categorically said, more than 60% of the population of Mumbai was living in the slums at that particular point of time. Now, of course, after that, so then you had the Maharashtra Slum Act that was passed in around, let me tell you the date, around 1971. Now, in 1976, the MHADA Act, which we know as the Maharashtra Housing and Area Development Act, in 1976, it was passed. So the problem was mushrooming so much that these two acts came and the government started taking up these responsibilities of slum management, slum clearance and development on their own. Housing, MHADA also came in so that, it can give affordable housing. Now, under the MHADA Act, there is one more thing that came up of the Mumbai Repairs and Reconstruction Board, who was mandated that, you collect repair cess from the old buildings, the cessed buildings, and you also repair these buildings. In certain cases, they might even maintain. Of course, the rents would rather go up because the cess would go up. However, this entire experimentation was not very successful. Not many buildings could be repaired. And even the ones which were repaired, the work was not satisfactory. In fact, where there was no leakage, I mean, there was times, in fact, this is a personal experience. So MBRRB was called to repair a particular thing and they could not probably fix that after carrying out the repairs. But where there was no leakages started. And this is personal experience that I'm telling you. So, this was the thing. Later on, under the MRTP Act, you need to make the regional plan and the development plan. So in 1991, the development control regulations had come up in Mumbai, wherein this concept of FSI and everything came in Mumbai. It was the island city, it was 1.33. In the suburbs, it would be 1. Now, in the meanwhile, the landlords had also challenged this rent control legislation. The famous case is known as the Malpe Vishwanath. In around 98, the judgment came. The Supreme Court was about to strike down the Rent Control Act, the Bombay Rent Control Act. But the government said, no, we are coming up with a new act and we are going to address these issues, and that would be better. It will be based on the Model Rent Control Act of the center. And, please don't do this. It will create some problems. We'll do it. It is because the Supreme Court said, okay, fine, we are not doing it because of your undertaking that you're giving. Now, until 1999, though the buildings were not being maintained or they were not being repaired on a major scale, of course, some landlords used to carry out these repairs on their own cost and everything. But until 1999, 2000, it was still okay. You would have started repairing, things would have been better. But that did not happen. The 1999 Maharashtra Rent Control Act that came, it only provided for 4% increase. Now, 4% increase annually, but on what? On the frozen rents of the 1940 levels. So it was virtually an eyewash. It really didn't mean anything. So again, the landlords did not really maintain this building. So you can't really blame them for that. The tenants were also not maintaining. Okay, we are not owners. Plus, the Rent Control Act says that the landlord should be maintaining. And even if they were doing, all the tenants had to come together. There were substantial majority should be doing. So, in short, encapsulated form, nobody was interested in this. It is from this 2000 period onwards that the buildings, a lot of them were started deteriorating. And Komal, you were talking about your experience that one building came crashing down. Now, of course, one of the reasons is because a lot of people were doing illegal alterations to it also. In fact, many of these buildings which were constructed in the 1900s to 1940s or up to 1950s, the life of this building was supposed to be between 100 to 150 years. In fact, even more, if they were properly maintained, they can go up to 200 years. Look at the case of Victoria Terminus, the BMC's old buildings, all these old buildings in Fort Heritage, because you're mandating repairs and maintenance, they are surviving. So even the other buildings could have done that. But anyway, we'll leave this topic at that. Now, in the early decade of 2000, there was an amendment to the DCR 1991, wherein the concept of incentive FSI was brought in. Now, this is your, you have been waiting for this time that, when I will really start talking about the redevelop. Now, this is the time that I'm talking about it. So when this came, they said, okay, your existing area plus the area that you require to rehouse these existing tenants, on that we will give you incentive FSI 50%. If there are more plots, then it will go 60%. All the more plots coming, then it will go 70% of the area required for rehabilitation. That is the latest figure in the prevalent 1991 regulations. Of course, FSI also gradually moved from 1.33 to 2, 2.5, and ultimately 3, which we saw it up till the year 2012. Of course, in the new DCR also it is there, but I'll tell you the variations later on. So all these things happen. Now, this was a good thing, but in my opinion, it was a patchwork. And why would I say that? Because there was a group of environmentalists, which I'll not name them right now, all based in Bombay, real intellectuals, who said, okay, you're talking redevelopment and all, it is fine, but still we are challenging it because the city of Bombay cannot take this load of redevelopment and the existing tenements. Why? Because the sewerage lines are old, the water supply lines are old, and we are not equipped. The city is not equipped to take this additional load. And the fact of the matter is, in your own experience, you would see that earlier water supplies to come, you really need not install the water pumps. Now with these new buildings coming up, there is actually a water problem. You have to install pumps. Even a first floor residential flat needs to now install a pump, except if it is a housing society. So you see, there is a water problem, and they were challenging that, and they were right. I'm not saying that they were wrong. Then the environmental impact of this, because so many buildings undergoing redevelopment, and imagine the pollution level that will come. Yeah. Now, so they challenged it. Of course, the state government wanted to protect it. There was a property owners association who said that, it is our property. We will be the interveners on that. 2 rounds of litigation happened between the Bombay High Court and the Supreme Court, which is known as the Vivin Joseph Pereira case and Jayant Achyuta case. Of course, everything was settled in 2006. The incentive FSI for redevelopment was upheld. Now, I will not get into the nitty-gritties of the writ petition, but the encapsulated essence of this thing is that the lives of the human beings took precedence over environmental concerns, because both of ultimately human life took precedence on that. So redevelopment, as we know today, is because of DCR 33.7 was upheld. Now after that, 33.8, 33.9, which is about the cluster development, because see, when 33.7 came, the plot sizes would range anything between 300 square meters to 4,000 square meters, 10,000 square meters, whatever. But majority of these plot area, if you see the C ward, D ward in Bombay, they're all actually very close to each other. They are very small plots. Now, of course, this was saved. It came up with its own set of problems. But though the regulations were in place, the mindset had actually not changed. So, you had a lot of resistance from tenants. You had skepticism from the landlords at that point of time, because, by that over a period of 70 to 100 years, third or fourth generations had come into place. They had own internal litigation amongst themselves, and redevelopment projects had issues. Builders at that point of time, we had, of course, the FSI was there, but things like flower bed was there, which was free of FSI. There were many other areas which were free of FSI. And builders started giving a lot of flower beds. Sometimes in some cases, the flower beds were virtually twice the size of the flat, nearly that. And they would pay premiums on the actual real FSI. And later on, the flower bed area used to be included after the occupation certificate was done. And that is what the government at that point of time. And that is when you see that, the regulations started becoming more and more stringent. Now, here I'm pausing for a moment and I'm telling you the strictness, the stringent regulations that we have from the government, from the BMC in redevelopment projects, and which the builders today are complaining, is something that they have invited for themselves. Any which ways, all these difficulties that were being faced, they said, we're going to put a cap to this. The then municipal commissioner in 2012, he says, no, they will give you the concept of fungible FSI also came into vogue. And they said, 35% more, you do whatever you want to give a balcony, you want to give a flower bed, but do it within 35%, whatever you want to do. So the rehab tenements, it was capped at 35%. For the sale component, if anything more you want to give, of course, you had to pay a premium. Now this fungible FSI is again only for the 33-7 projects, the old CEST buildings. And yeah, these things came up. Now, difficulties or no difficulties, today there are around, nearly around 50 NOCs that you have to take from the time, all the tenants consent to it, and the stage up to the CC, anything between 2 to 3 years go. Now, this is actually a patchwork solution. Now, of course, this is a necessary evil in my own.
Sorry, it is 50 NOCs from? 50 NOCs from
various departments, like now
no,
if you're...
you mentioned the stages. I'm sorry, you mentioned the stages. That's what was missed.
No. Stages, now the stages from one stage to various stages, first of all, you have to take these tenants into confidence. Then they give you the NOCs that yes, we are okay with redevelopment. Then there is a process of drafting of the plans. Now all these plans again depend upon which kind of property are you redeveloping. But assuming it is only to go to the municipal corporation, you show them these plans, then you have the fire NOC, then the municipal corporation, the engineers, they tell you, make these changes, don't make these changes. Then there are hydraulic departments. If it is a municipal land, you will have to go and taking permission from the municipal corporation, from the estate department. If it is a port trust land, you take permissions from from them. If it is a collector's land, you need to see the covenants, what are available over there. So there are various kind of things. A more apt person who can really take you through all these things are the architects, because they normally do these liaising. There are liaising architects available. And the exact process, Komal, since you're going to organize a detailed program for various other kind of redevelopments, you can take it at that point of time, because each kind of property is going to have a little variation. So there is not a straight jacket, one particular document that, we can say, this is exactly the process. The intention being that this is being the overview. Now, again, I will come back to the cluster redevelopment aspect of it. Why cluster redevelopment was thought of. The minimum plot area had to be 1 acre, basically 4,000 square meters. Because in between, people had realized that, 500 square meter plot, what can you do with it? You couldn't provide many amenities. There were challenges to urban planning. There were also in the DP plan for road widening and everything. And if all these small plots were allowed to be just redeveloped on their own, then this urban planning was a problem. So they came up with something known as the DCR 33/9, which is the cluster redevelopment part of it. Very few cluster redevelopment projects have succeeded. One of them is, I think, the Saifi Burhanuddin Trust that is doing. A few others are, of course, there. But majorly, they could not take off because they had a provision that though the FSI was more for them compared to a regular DCR 33/7, but a large area you had to share it with the MADA, and some of them had to be given to the BMC. Of course, in 33/7 also, if the incentive FSI is much more something, you still had to share it with the government authorities. But in cluster development, that became the problem. So you had to construct more area, you had to give more rehabilitation area, you had to pay all the premiums, you had to pay all these taxes, you had to pay all these charges. And mind you, in those days, land under construction was also taxed by the municipal corporation. That put an additional burden on them. So all these were included in the project cost. And the government used to say, you give all these areas for us for free. And especially lands which had reservations on them, you had to give those reservation amenities to the concerned authority, which also got included in the project cost, and you had to give all these things. So cluster redevelopment projects, they in fact became unviable. Sometimes the returns on them were lesser than your regular 33/7 of that. So this was all about the problems that redevelopment projects face. Of course, there was overtrading by the builders also. Money in this particular project would be put in some other project. All these things we were seeing. Yeah. Now, the good thing that happened is, RERA came into force. It was an effort, a central piece of legislation which the states could adopt with whatever variations. Maharashtra also, of course, adopted. What is happening in Maharashtra would be different. I'm not a RERA expert, but I see that one of our attendees today is also a RERA expert over here. But anyway, now in RERA, again, it gets triggered only when you are marketing the project for the sale purposes. But when you're initiating a project, when you're doing redevelopment with the tenants and everybody, it is a different ball game. That is not the point of time that when it is getting triggered. Various different kind of lands will have different kind of laws that are coming into force. So, you would really want to know what kind of laws are applicable during a redevelopment. So I'll just mention them shortly. First of all, everything, your parent act is going to be the Maharashtra Regional and Town Planning Act, because that is what is giving you the regional plan. It is what is giving you the development plan. And that is also providing for specific town planning. So if you see Mahim, if you see some areas in Bandra, there are specific town planning schemes also. Then, of course, the planning authorities are given. So for slum rehabilitation, it is the SRA, which is the planning authority. For regular lands, self-buildings, the planning authority is, of course, the BMC earlier. But NBRRB was given the mandate to find out who are the legalized tenants and occupants, because only the occupants would be given this place. It was the concept of tenancy was going, the real tenant may not, but the occupant will get the flat. The other disputes as to title would be a different matter altogether. Now, when it comes to BMCL lands, again, you have to see what is the BMC's policy on that. Collector lands, you have to see the collector's policy on that. For MHADA-owned societies or MHADA-owned lands, you have to fall back on DCR 33/5 or 6. I can't remember. I think it was 35. So all these things are coming. So every different kind of property, though old, requiring redevelopment, there are different set of laws that are going to apply. But the development control regulations are definitely over there. After redevelopment, when societies were formed, again, of course, the Maharashtra Cooperative Societies Act will come into play. If you are having apartment ownership, then the Apartment Ownership Act will come into play. So, there is not one single legislation which is dealing. There are a plethora of laws, and with the plethora of laws, there are plethora of rules, regulations, notifications, circulars, policies that are coming. And for that matter, when if anybody wants to talk about, ask a question, particularly about a thing, I think, they should be asking in a subsequent session that you're organizing, because each and every part is an ocean by itself. So yeah, having said that, slum rehabilitation had its own set of problems, because a lot of building regulations which were applicable to general buildings, in slums the builders were asking for relaxations. Now, for example, between two buildings, there has to be a mandatory open space, there has to be a distance. But for slums, those relaxations were given that, the distance between the two buildings should be short. Even if it is shorter, it is fine. If the mandatory open spaces, if they are lesser, it is fine. Now, all these things had its own set of problems. Again, in slum rehabilitation schemes, it is the society of slum dwellers which should be formed. Then you had a problem of rival builders, encouraging rival societies, and the slum dwellers fighting amongst themselves. And then there were a lot of other red tapeism issues, and there are certain issues we wouldn't talk. I think everybody knows that when governments and authorities get involved, how the process goes on that. And any which ways, the redevelopments that we are seeing right now are such that the minimum area that is to be required to be given to these tenants, whether you're 100 square foot or a 150 square feet, in a 33/7, of course, you had 300 square feet plus fungible FSI of 35%, which were given to residential and 20% to commercial. Now, in the new DCR that has now come, that is DCPR, from DCR, it has now become DCPR, Development Control and Promotion Regulations, that they are coming up with, that the commercial establishments can also have 35% more fungible FSI. This is one welcome move that they made. But there are so many things that the authorities are not taking care of, I feel. For example, for the new sale area flats, you have parking per tenement, per flat that is being constructed. But for rehabilitation concept, we are saying for every 45 square meters, every tenement of 45 square meters, 8 tenements of 45 square meters, you will have only one parking. Now, when such regulation, I'm just giving an example, there are a plethora of problems on that, but I'm just giving you an example. Now, everybody requires parking. Even a tenant today has at least one two-wheeler or at least one car. Now, if between 8 such tenements, if they're going to provide one, then all these cars are going to come up on the roads only. Then you
Absolutely.
Then you are going to cry, oh, these cars are coming on the roads, and there is congestion, there is traffic, there is pollution. Then what do you do? Now, recently, everybody knows that, if you park your car on the road in certain areas, you'll be fined 10,000 rupees.
Yeah.
Unfortunately, we are drafting such kind of regulations that are leading to different kind of problems. And you don't want to address those kind of problems. So these are the kind of problems that we are facing. Another thing in redevelopment that I have seen, that today we are talking about, the building technology has improved, we are more technologically advanced, and whatnot that we are talking of. This is old buildings, had they been repaired and maintained for 100 years or so, they will not have a leakage. Cracks used to develop only after 70 years. In many of these new constructions that we see, second, third year cracks and leakage have started. In certain buildings, in the very first year of its construction, they have started. So what advancement are we talking about? In redevelopment, why am I talking these things? Because I don't think so we are really advanced in those things. We are going vertical, yes. But on the rehab component for slum dwellers and old tenants, we are actually constructing vertical slums over there. I'll give you a case in point. In the old DCR, it was not mandatory to give you self-contained WCs. Self-contained toilets were not mandatory. People were giving it as a different matter. But there are certain projects in which these were not given. All right. Now, today in the COVID scenario that we see, I was talking to some people from the chores, and I said, okay, social distancing norms are not following. I was just telling them, I wouldn't name them. They said, we are not following, but what is the point? Because, we are keeping a limited distance. But the real problem is that in the chores where we have to go, we are using common toilets.
Yeah.
That is where the risk of infection is there. So people who oppose redevelopment today, you really need to know that if you get a self-contained apartment today, this is I'm telling to all the tenants. You get a self-contained apartment, you get larger area, you are getting a flat on ownership basis. And if you are getting a flat on ownership basis, you will be able to mortgage that flat, you will be able to raise certain kind of finance, you can sell it, you can do whatever. So why are you opposing? Many of them say, nay, 35%, 300 square feet plus fungible, itna to, government is giving us. What are the builders giving us more? Now, of course, this was a problem 12, 15 years back more. Today, a lot of tenants have become smarter. They understand, but still, in certain areas, we still have these kind of people. So I don't see a reason why.
I have, sorry to interrupt. I have a connected question here from Aditya, which says that, I think the basic of the question here, intention is who will decide and after what time will you decide that, okay, now this building should actually go for redevelopment. When it's tenants, then how will that process initiate,
Cool. So here what has happened, again, I'll go a little in posterity. Earlier, only cessed buildings of A category were allowed to undergo redevelopment, which are also, again, dilapidated only. Under the new DCPR 2034 that we have got, they're not making distinction between different cess categories. A, B, and C were there. Now you are in any of these cess categories, you can directly go for redevelopment, because now the idea is that you need not wait until the building gets dilapidated. So before the building actually becomes dilapidated, please go ahead and redevelop. Why do you need to wait for that? So in 33(7), that is the case that is happening. Now there are certain buildings which are destroyed by fire or demolished for certain other reasons. They can also undergo redevelopment. I'll tell you the regulations also. So they can go redevelopment. Then in the new DCPR, a lot of people were saying that, in suburbs, 33(7) is not applying. What should we do? So for them, a new DCR has come up. I'll tell you so existing residential housing societies are under DCR 33(7)(b), and 33(7)(a) is for old, dilapidated and unsafe tenanted buildings in the suburbs. 33(7)(a), it is coming. So even if the building is not dilapidated, but it is certain years old, you may still go ahead. The only thing over there is that the incentive FSI will be lesser. It will not be as much as 33(7) is there. Now, what the exact nuances of that, how much we will get, that is very elaborately given in those particular regulations from 10% to...
So is there a specific number of years that must have passed before someone can go for or...
Yes, yes. So I'll tell you, for MHADA buildings or BDD chores, there are different regulations for different kind of things. In fact, for slum rehabilitation, it is different. For Dharavi, there is a separate, and the number of years and everything is being clearly laid out over there. So you can have a situation that, my building is only 5 years and now my FSI is more, so I will go ahead with it. It is not that kind of. So all these kind of scenarios have been provided for. All these kind of scenarios have been provided for. Earlier, housing societies in the suburbs could not do that. But of course, the incentive FSI is not that very high that it can justify, because, the premiums are very high. I have made a small list, which was coming to my mind, what are the difficulties in this redevelopment projects and all, what are the suggestions that we can do. But, if anybody has questions, we'll take up questions only which are asking from the macro point of view, not on specific technical details of how many years and how many this thing, because as I told you, Komal, you'll have to organize, for 33(7), you'll have to organize, for 33(9), you'll have to organize, for slum, you'll have to organize with a particular expert, and probably an architect is required if such specific technical things are required. For transit accommodation, there is a separate DCR regulation, sub-regulation that is there. So you have to look into all these things and then you decide.
Yeah. Yeah. So again, the decision taker will also be different depending upon the different properties. So like for tenants, there has to be a particular amount of consent that is required. Or in case of properties that are owned by cooperative societies, also a specific amount of percentage is required. So
Yeah.
so that's like the start of the process, right?
Yes, yes. So see, earlier I have dealt more with the landlord-tenant properties, all these pagdi system old buildings. Earlier, you needed to have 70% of more than 70% of consent, which under the new DCR it has been reduced to 51% now. So if you have consent of those many people, they are irrevocable consents which have to be given to the MADA, and then only MADA will come and they will inspect the building. They will see whether how many are authorized occupants, how many are not. Then there is a cutoff date. You need to have those proof. They make an annex two of that, and accordingly only their consents will be considered. Their existing areas are taken into account, and on that you will get an incentive FSI. Fungible FSI will be calculated on that. You know, again you will have to see, because under MADA and BMC the concept of FSI carpet area is different than the concept of carpet area under RERA. They are two different things. So you really need to look into all of that. But as far as the consent part is concerned, this is what the consent is. Even for housing societies who want to undergo, they have an additional thing, because there are guidelines that are given, how much of percentage of people should be coming together. There has to be an annual general meeting, that has to be video recorded, there has to be a project management consultant. People may probably bid for that also. Tenders have to be floated, and they are pretty strict, because that is the due process of law that they have to follow. Some societies are undergoing self redevelopment also, which is a good thing. How successful they are, it only time tells. Some of them have been successful, some of them will find it difficulty. The questions of risk taking ability of societies members also arises, because most of them may be professionals, educated, but then the finances are required.
Yeah.
One thing that I would like to say on my own is that the real estate sector currently is undergoing a lot of financial problems. Projects are getting stuck. RERA has come in, and it is good for genuine, sincere builders, but even they face problems from the sale component. Whatever revenue comes, they may have to put some money in the escrow account, and only phase-wise some money can be released. All this, so there is a cash flow pressure that is putting on them, which earlier they had a free hand to deal with. Tenants also expect that a temporary transit accommodation should be provided to them,
exactly,
or else to give rent in lieu of that. So that is an additional thing. Now these things are essential. When you are having so many kind of NOCs, in SRA they say there is a single window clearance. Now how that works, let an SRA expert speak on that. But over here, today, the government authorities, they expect you to pay the premiums upfront, the development charges upfront, the materials and everything that we're having. Of course, you pay GST, so I'll not get into that. Until recently, land under construction, the property taxes were much higher than a fully occupied. Now, which was illogical, because a building which does not have a water supply or sewerage, while it is under redevelopment, how can you charge them more? Of course, there had been a writ petition by the Property Owners Association, and there were 120 other petitioners, land under construction, that taxes have been, they have been struck down. Of course, this matter is today lying with the Supreme Court. But you see, so much of cost, upfront payment these builders had to do. And then the cost of the project goes up. And then if there is a litigation, even for 6 months, 1 year, the profits are gone. So, these are all man-made difficulties that we have created. I fully understand that there was a time that builders have invited this kind of problem for themselves, but the current rules, regulations that the government is having, the policies that they are having, they are exacerbating this particular problem. Why can't you have a system of deferred payment? Let the building come up, let an occupation certificate be given. After that, and when you are giving your water supply to them, when you are giving them the sewerage system to them, when it has become operational, from that point of time, you start charging them all these premiums and everything that you want. And why am I saying it for Bombay? Because see, elsewhere, this problem of redevelopment is not there. People don't have to pay to the tenants. The land rates over there are lesser. The charges are not very high. And to add insult to injury, today all these premiums are now being linked to stamp duty ready reckoner. Can this be done? So how do you have control over that? A sewerage line or a water supply line given at Kolaba, which has a higher rate, property rate, or one given at Dharavi or one given at Dahisar, is the cost different? What are you charging these development charges and all these premiums for? What are you doing it? Basically, it is to add to the municipal corporation or the state government's revenue to provide you with infrastructure. Is the infrastructure cost very, very different?
Yeah.
And how can you link it to the stamp duty?
Area, exactly. Yeah.
Your property taxes today are also linked to the stamp duty ready reckoner. Is the cost of giving water to Kolaba more than Dahisar? Maybe Tansa Lake, Virar Lake, maybe closer to Dahisar, but then it is not so very high. So this problem has got exacerbated. It has become worse when everything you are linking it to the stamp duty ready reckoner. One of the suggestions that I have is for cluster redevelopment. All these small plots of lands who are there. There are many owners. Owners have their brothers and sisters. Now many of them may just want to sell off that land. So if you have a developer who is aggregating these 4-5 plots of land, making it a 4,000 square meter plot, and then in those lands, you can have a better planning, you can have a better development over there. In smaller plots, you can't even give a play area to the kids. There is no recreation area. You are unable to give even open, you have to take concessions for open spaces also. But if you have a cluster development, if MADA is saying, okay, we will not take this additional area from you, okay, and the charges, if you are reducing it, and if you are reducing the stamp duty that is attracted when these land lords are selling it to the builder, or a development agreement is happening, instead of 5%, 6%, you bring it to a nominal percentage, then the transaction cost reduces. The aggregation of plots increases. You are able to give more money to these landlords who will be more than happy, because of proper chunk they are getting it. They like to exit. When there is only one single owner, if the developer becomes the single owner of a number of lands with very less transactional cost, he can aggregate these lands. Better planning comes. You can provide a garden in that particular aggregated land area. More amenities can come. The cost of construction reduces because you don't have to go very, very vertical. Because the higher you go, the cost of construction also increases. So there are so many benefits. And the builder is going to get money when? When will he get money? Because when the sale area is coming, he will get the money. That is the time that at the time of occupation certificate is where most of the sales are happening now. I'm not saying it is not happening during the under construction phase, but now the market sentiment, how it is. Nobody wants to invest in under construction projects. Even the investor classes is saying that, we really don't want to get into it. Very few under construction stage they are buying. So only at occupation stage are the buyers going to actually buy the flat. That is where the revenue is going to come in. That time you charge all these premiums. Why can't you have a deferred payment? Today, business, not only real estate, business everywhere is about cash flow management. It is not about bottom line. It is not about net profits. It is not about book profits. So if you are able to give this cash flow ease to these builders, they can do a much better job. Of course, you regulate them. This is a breed that you really need to regulate them, because a little leeway and, a lot of other things can take over. their mind. I'm not using the words. So these things can happen. These are some suggestions you can, the government needs to consider. And when this happens, bigger plots can come in. So you can give parking spaces, more amenities to even these tenants also. You will not have problems of parking on the roads. Even your other infrastructure, drainage, sewage, other things, road widening, even this will require an impetus rather than you having to go and acquire certain contravening structures and paying compensation. In a larger 1 acre plot, you can do so many things over there. But for that, this sacrifice has to be done by the government and the municipal corporation planning authorities also. You know, every time if you're expecting that the private sector should make all the sacrifice, the private sector should take the onus of everything, I think it is high time that the government also needs to make certain sacrifices if you want your socialistic ideas and your socialistic goals also to be achieved. If you're going to do a patchwork solution, this is not going to work. If you are going to put everything on the private entrepreneurs, things are not going to work. Sacrifices have to be made at every quarter. Greed, you know, many of the problems are because of the greed. Either the builders get greedy, the landlords get greedy, the tenants are no less greedy. The government also wants all the payments upfront. Now they have started deferring something, but you know, this level of deferment of payment is not something that is going to help very much. Therefore, they have started deferring, taking deferred payments and all. I'm not saying no to that. Some relaxations are being given, but why give it in a piecemeal manner? You know, have a holistic approach to this particular problem. Only then redevelopments will become at a faster pace. It will become at a rapid pace. All this problem of old dilapidated buildings will go away. First and foremost, you know, stop vilifying the landlords also. Trust me, it is not their mistake. They have been put into this thing. You know, it is no politician likes this kind of statement, but the fact of the matter is it is true. When the tenants also have to understand that, you know, when we came over here, we did not put any money over here. Well, some of them may have come through the Pagadi system, but there are so many landlords of 2,000 square foot or 2,500 square feet tenements that they have let out. They have never received any benefit of Pagadi. So rather than getting into tumko to Pagadi mil gaya, abhi kya hai, let us acquire your buildings, this is not going to work. People are going to go and challenging. So create a situation which is win-win to everybody. Government should take its by the last. If this is adopted, things will become much smoother. Make it a single window clearance system for all kinds of redevelopment projects, I'm saying. Then if you tell the builder to come in discipline, it is a good thing, which even on their own they should be. So, you know, these are some of the problems that we see, some of the suggestions that we can find. One more thing that needs to undergo a change, which I think, you know, a few days back, Sri Ratan Tata also spoke. You know, he's an architect by profession, so just became passionate and he spoke about it also, in which I have been doing over the past 10 years at various, when the new DCPR was coming, I had given a suggestion and objection also. You see the old chawls that are there, they have cross ventilation. So they have the main door, they also have one window behind. So the air comes from one portion, it goes out from the other portion. So the requirement of air conditioning, air cooling is less. The requirement of putting on the fans is also less, because these 180 to 225 square feet tenements also are having cross ventilation. Now you see in the new buildings that are coming up, you know, I'm sure a lot of people stay in new buildings over here. 1 BHK, 2 BHK tenements, the air circulation, the air inflow is through only one side. So even if you have a window in a bedroom, you have window in a hall, the air is only coming in through one direction, either northeast or east or west, or, you know, there is one. Only from 3 BHK and above are you lucky enough to get ventilation for, I mean, the windows which are open to two sides, you know. So were our ancestors more smarter than us, or are we smart? So electricity consumption and everything also is coming into it. Now today, when everybody in the COVID scenario, I mean, why am I saying that? Maybe probably I'm exceeding the time also. But while we are doing this, in COVID scenario, most of us are expected to stay inside the homes. Now, in the earlier regime, when the fungible FSI was not capped, fungible FSI wasn't there, but so people used to provide balconies also. They used to provide sky decks also, and assuming people who are quarantined right now, if they even go to the balcony, which they can go, and they can get the fresh air, they can have some sunlight. Now, after 2012, builders have stopped giving balconies. So people in new construction where there are no balconies, imagine their plight. Just imagine their plight. No fresh air, no sunlight. What are you going to do with this? So when we are talking about redevelopment in this overview, I'm saying just don't provide the regulations over here. Your urban design, your building design, even these things need to undergo a change. What is happening at Dharavi today? There are many hotspots, but in Dharavi, you really can't have social distancing.
It's not possible. Social Absolutely.
You have not redeveloped those areas today because, again, there were so many problems with that. There are a lot of people to blame. Slum dwellers, nahi hamara to ye system hai. And, it is an industrial belt also. Dharavi is not about vertical buildings. It is about something else. We were also, there are a lot of problems that happen at that point of time. Chawls also, this is what is happening. Now, problem for chawl owners is even if either the building goes down, there's lockdown also. I don't know if it gets lifted on 3rd May, 4th May. I'm more than happy. But if it doesn't, and people will go mad with that, either the places where people are hungry, people might just get into depression also. But if you had some recreation ground or balcony sky decks, things would have been so nice. Another issue is that when this open space requirement between buildings is so less, then the issue is that you have 20 towers, 20 floor towers, you have 30 floor towers over there. And when they are close by, you are either not getting the morning sun, you are not getting the evening sun. Even you may have a window, but if you have a huge building in front of your window, so no fresh air, no fresh sunlight. What do you do with this? And fresh sunlight, as you know,
or no privacy for that matter.
No privacy for that matter. And fresh sunlight is so important for your vitamin. All the A, B, C, D, we may go into all those vitamins and all. Sunlight is the killer of germs. If you have breathing fresh air, so many diseases can be avoided. So what have we done to all these things? Your B ward, C ward cluster is required, but still people are going to oppose. Landlords are going to oppose, and rightly so, because if you're talking about acquisition of these buildings, why? You created this kind of situation. This entire problem of housing in Mumbai, from old buildings to slums to BDD chawls, you name the thing. It is a classic example of political patchwork experimentation. And, having said that, I don't want to go on further on that. But when we know that this is a problem, this is the root of the problem, the measures that we try to implement, they are not working, then at least now give a free rein to, market dynamics, free market dynamics. Of course, the capitalism has to be regulated. Governments can have socialistic goals and they must strive to be a welfare state. But governments must not forget that only regulated capitalism can achieve those socialistic goals. Stifling or killing free market dynamics will only damage the society at large. It will never benefit. The problems were simple. They have simple solutions. You need to address the root of the problem. Ultimately, on a closing note, I will only say that greed may be good, but excessive greed is bad. Everybody has to take certain kind of sacrifices. Government must lead the way in this particular thing and try to make your rules and regulations simpler, your premiums and charges simpler. Take a deferred payment for that. Stamp duty when you are doing, when the building is fully constructed, at that time from the sale area, people you take your 5% and plus 1% says that they are taking 6% of it. But while landlords are trying to sell the buildings or developers want to take over those properties, reduce the rate of your stamp duty, the transaction cost will go down, bring about a change in the urban design and planning. These things are required. Cluster development is good, but all the negativities that are coming with it, the government must address. Please let go of your pound of flesh, because your NHA is going to earn by way of premiums and other taxes and charges that you are having. If people are making money, developers are making money out of it, it is good. Ultimately, they're going to pay taxes out of it also, no? So why they are getting so much of money out of that? This should be the pound of flesh. That should not be the attitude. Capitalistic tendencies must be there with the entrepreneurs. Governments should always be more of a welfare state. It should achieve those socialistic objectives also. The capitalistic tendencies, capital value system of taxation and charges and everything should not seep into the government part of it. You should only raise that much of money that is required by you. Charges should not be for augmenting the resources of the government or the municipality or any other authority to make it into a chest and gold mine. That should not be the thing. And I think if these things are taken care of, redevelopment has a good idea. That is it. Of course, the next problem that we'll probably face will be after 40, 50 years, when these redeveloped buildings will also become old, and these 40-storied, 30-storied towers will also require redevelopment, and then we will be talking about 100 and 150 stories. So that's why I said, even this is a patchwork solution, which will only help us for the next 30, 40 years. After that, what will we do? So a very, very different kind of approach is required in this. But I think a great amount of damage has already been done. So now what we can do best, that is the way forward that we should go. On that count, I think I will end it over here. Thank you. Any questions? Of course,
yeah, I think someone
let
is
it
very
be on a macro level. Let it be on a macro level, not on specific this thing.
No,
because for that we have different
we
sessions.
enjoyed the whole details of it. I think it will be a much more detailed topic for someone to actually get into and understand how to carry out. Someone has summed up the procedure here in some steps for redevelopment, but I would believe that this entirely depends upon kind of the type and everything that is looking for. So he's just kind of summed up to get the consent, and then once you get the consent, you have to work on the plans and the terms and conditions. Then once someone was actually asking for these steps, so therefore, like I am just repeating what is put it down as his points. And then once you have the agreement, then you get ready, then you get the layout plan that is passed by the BMC, and you get the intimation of disapproval and the commencement certificate. And once commencement is received, then the members can start to move to alternative accommodation or something else that's provided. And if the land is not available in the society, then they have to take approvals again for shifting to another place. Once the project is ready, which is like saying one thing, but having it implemented is completely another. So once the project is ready, and like it's there, then you can have people shift back. But even that, at that point of time also, you get a lot of hindrances right from the people itself or from the members itself, where they may not give consent, they may not exactly want to move back to whatever is provided. There can be issues like that that arise right from the people who are involved or getting affected or going to be benefited by redevelopment, if I put it that way. So I think it's very well put here, the points. But isn't it?
In fact, of course, the seminar is about us. There is, I think, one person who has joined is one advocate. Tejas also has joined. He's also an expert on redevelopment also, which I can see from the screen. Something more you can ask. And I mean, of course, this is our session for the speaker, but there are many lawyers. If you have to add, one can really feel free to it, because as I said, though it's a webinar, but some experts can also say further on that. As far as I'm concerned, I'm going to answer only the macro point of questions today, because that is what the intention has been for the thing. Other things, of course, Komal will be organizing.
Yeah. Great. So, but thank you for just giving that overview, even the background of why redevelopment is typical for that matter to Mumbai, and what really started, even the background of laws for that matter as to how it came into being and why people are looking at, getting it, and also, of course, the issues as you nicely covered that are faced more. I mean, not only from the point of view of the people or the consumers, and but even in the point of the view of the developers or the builders who are actually going to be involved in carrying out the redevelopment. So
Yeah.
like good sharing of really commercial or factual aspects here. So I hope people really enjoyed. I don't see many a lot of questions here. Someone has actually hit out at what is the corruption that goes on at every stage during the redevelopment, and you have government decisions which are biased towards developers, or permissions are given illegally. So well, BMC, I like BMC is the entity that is you have to interact with at all stages here. So nothing needs to be said. Like, I don't think we can make
No,
any
even
statements.
a simple thing since it has come. If you see some of these buildings at Hiranandani Powai, the kind of
Yeah,
rooftops that they have, so beautiful.
yeah,
So earlier these things were excluded from the FSI. Now new regulations, even they will be counted in FSI. So what the builders started doing, they did not give those decorative rooftops and
yeah,
those things that we have. So now all these new buildings, when we see, I mean, inside they might be good, but you don't really feel like looking at them. So these are the kind of small things that really go on. I think one has to really look at the beauty and aesthetics aspect also. So people who should be planning the city should also feel the love for the city. I must say, I don't know if that was there, probably we would not be in the situation in which we are.
I don't think we can make any statement about beauty and Mumbai, like saying both of them in the same breath is, I don't know we can do that really. So
Yeah.
being a Mumbaiite myself, I can say this, that we can't have two of those in the same breath. But
So one more thing, one more
Hiranandani,
thing.
definitely, as you rightly pointed out, people used to kind of go to the distance and see that, okay, yeah, it looks like a really good property even from a distance somewhere. But as you rightly put, like, that is also not to be in the newer buildings.
Of course, of course. There are many points, of course. Anyways.
Thank you for sharing so many things passionately, Mr. Shah. And I don't think we have, yeah, I have a lot of inputs here for you. So I would like to read out this one. Jayob is a very good counsel. He has taken such efforts to explain the background. Such practical experience has been nice enough to share. I'm sure everyone has benefited from it. Thank you so much, Mr. Purohit. It's coming from Ashok Vardhan Purohit. So yeah, I mean, like,
Thank
people
you,
who are
Ashok.
insiders to this would really know how things work. So brilliant. I think we don't have any questions, so I think we can end the webinar here. But thank you so much for bringing a completely different light to the topic, rather than people talking about just the regulations
No,
or parts of
yes,
it.
I specifically. Anyways, thank you, people who have attended and for of course bearing with me until now, and wish you all good and safe, sound health. Please stay safe, and God bless you and everybody's families. And hope we come out of this pandemic safe and sound. Take care. Bye bye.
Thank you so much, everybody. Bye.